Okay, I think that swap went remarkably well. So maybe let's get started again. If everyone could settle in. Great. So we're going to do the same thing. We now have the other side of the table represented. So we'll do the same thing. We'll start with the intros. We'll do some questions, which I'll lead, and then we'll ask everyone to come back up, and we'll do Q&A from the audience. So John, if you could kick us off with a 1 to 2 minute introduction of yourself, a little bit about how you got to where you are, and something about the firm and your areas of interest that you're looking to invest in these days.
Definitely. So I'm John Lamb with Osage University Partners. I think I have the distinction of being the least experienced person on this distinguished panel. But Osage University Partners, we're a venture capital firm that specializes in university startups and spinouts. So we directly partner with a number of universities and will selectively invest in the companies that spin out of their research labs. And Oren was actually fundamental in the formation of our fund and has really been a great supporter of ours through the years. So we work with Columbia and have been working with them for a number of years. So the premise of the fund is to invest on behalf of the university in the companies that spin out of the universities. We actually invested in Vishal's company, Infinio, and in line with what Greg said, I have no clue what Vishal's company's technology is. Something with computers and clouds or something like that. But it's been a great investment. So we're a relatively new fund. We closed our first fund in 2011. That was a $100 million fund, and have invested in about 40 companies since then. We just closed our second fund, a $220 million fund, and we're really excited to be continuing our relationship with Columbia and moving forward to do a lot more deals. So the way that, I've been at Osage for a few years now. Before that, I was with Lux Capital for a short time. That's another emerging technology venture fund based in New York City. And then before that, I was in the corporate development office of a large conglomerate, the Mahindra Group in Asia, doing technology investments in everything from electric cars to IT and quite a lot of things in between.
And educational background?
Yeah, so I studied biology at Cornell University.
Oh, and now you're the phys sci guy at Osage.
Yeah.
Yeah, that makes sense. Okay, good. Great, thank you. Lee.
Yeah, sure. So I'm Lee Wrubel. I'm a partner with Foundation Medical Partners, which I started in 2001. My background is I started life as a physician, trained at Mount Sinai in New York, became a consultant for a couple of years, a firm called the Wilkerson Group. Went to business school here, and then I've been in venture capital, originally with Canaan Partners and with Highland Capital in Boston. And in 2001, I started Foundation. We're now investing our fourth fund. It's healthcare IT focused, almost exclusively, and we're going to do a final close in a week or two, but it's going to be about a $200 million fund.
Can you mention briefly, just you've got the new fund in particular is closely tied in with a number of strategic investors from the industry. Are you able to talk about that?
Yeah, so I can talk a little bit about that. So one of the things we see going on in healthcare is this radical transformation in the entire industry. And so it's brought almost every group to realize that they need to transform their own business model. And so we have a number of them as limited partners in our fund, where the fund becomes almost headlights on innovation for them to consider. And so we have provider systems like Cleveland Clinic and others. We have some insurers. We have companies like Medtronic, but we also have CVS. And so there's this really broad range of investors who we work with in this very engaged model as we work with them and show them companies and get feedback from them as a part of our due diligence.
If you're interested in hearing more about Foundation Medical Partners in particular, I did an hour-and-a-half interview with Lee, which is on our website. You can check it out. It was a conversation we had last year. Great. Stan.
So I'm Stan Reiss. I'm a partner at a place called Matrix Partners from Boston. We're a bi-coastal fund, Boston and Palo Alto. And if I look to the left, we're a big fund. If I look to the right, I'm 15% of Kittu's newest fund, so we're a tiny little fund. Kittu just raised a ginormous fund. So we have the latest fund is about $450 million. We've been in business since the 70s. We do early stage technology, which is sort of non-health, but maybe some health IT is kind of the as close as we would come to that. But we're not qualified at all to look at stuff that might do something to the human body. I've been there 15 years, and my background is I'm an engineer. I'm an overeducated engineer, so I went to grad school studying communications. I spent some time designing chips, sometimes a consultant, sometimes in business school, and I ended up in venture. When I finished business school, my thesis advisor from grad school had connected me to Matrix, and I was looking to work in a startup. I didn't know what venture capital was. I was looking to work in a startup, and they talked me into doing this thing. And I've enjoyed it, so keep in touch with those professors. Turns out they're actually useful after all.
Good example of that.
Cool. My name is Kittu Kolluri, and I'm a general partner at New Enterprise Associates. Let me first talk a little bit about our firm. NEA is a 38-year-old venture capital firm. It was founded in 1977, 78, and we started off bi-coastal, Menlo Park, California, and now Chevy Chase, DC. We were originally in Baltimore. And what is kind of unique about us is we have about 17 billion now, including the most recent fund under management. We are diversified across sector, stage, and geography. Sector-wise, we invest in information technology, healthcare, life sciences, and renewable energy, clean tech. And stage-wise, we write checks as small as $250K seed investments to checks as large as $80, $90, $100 million. And geographically, we're obviously headquartered here in the US, but we also have presence on the ground in both India and China, because we view those countries as countries of strategic importance. And in terms of the fund size itself, our most recent fund, NEA 15, we just closed, is actually a $2.8 billion fund, but we also have a $350 million opportunity fund, which is for growth equity investments. And just a quick word on the stage, or rather on the sectors. On the healthcare life sciences side of things, we invest in biopharma, medical devices, and in health services, IT services. And on the IT side, we invest enterprise infrastructure, communication infrastructure, software services, consumer internet, consumer mobile, the works. And a quick word about myself. I've been at NEA now close to 10 years, and I took a slightly different route than most of my partners. I came to NEA through the entrepreneurial route, actually. I'm guilty of being a serial entrepreneur of sorts. I was most recently, before NEA, I was the EVP and general manager for the enterprise business at Juniper Networks. And I got to Juniper by way of acquisition. I was a CEO of a company called Neoteris, which was the pioneer in the SSL VPN space. And we sold that company to NetScreen, which within 3 months got bought by Juniper. So I got to cash my lottery ticket twice. And then prior to that, I was a co-founder of Healthion WebMD, which is more on the health IT side of things. And prior to that, I was a software engineer at Silicon Graphics. And I'm a technologist by training.
Great. So I'm going to start off by asking the same question I asked the entrepreneurs, but from your perspective. So when you hear pitches from entrepreneurs, first of all, how early in the process do you engage around the topic of intellectual property in particular? And how important is the intellectual property and the due diligence you do into it, into your funding decisions? And anyone who wants to take that can take that.
I can take it. I guess it really depends, right? If we're backing a software company, it's highly unlikely that IP matters at all. So if it looks very important to entrepreneurs, we'll pretend that it's very important to us and tell them how smart they are. But it's highly unlikely. It's highly unlikely it'll matter. Maybe some key algorithm, but in general, that more of that stuff gets developed after funding than before funding. If we're investing in some kind of a semiconductor company or something that's got much more fundamentally based on technology, then what I spend more time on is freedom to operate than anything else. I just want to make sure that they're not stepping on anybody else's technology. And then, my experience has been that even if they come with a great patent, that's a plus because it's it shows that these people are capable of developing IP, but again, most of it gets developed later. And we're trying to forecast the future as opposed to look at the past.
But I think it depends on the sector. So, medical devices or biotech, patents are critical. And so, at a first meeting, that's a topic that's going to get covered. And it's going to get diligenced seriously later on. I mean, because you have to spend money on it. So you're not going to spend money unless everything else is checked out. But it's going to be one of the last steps is to hire an outside patent attorney to figure out, the landscape. Not just this patent, but what else is out there and how's it together? How good is the picket fence around what they want to do?
I would say that it largely differs on the type of opportunity. We invest in a lot of hardware companies and electronics companies at Osage, and in a lot of these situations, we actually look towards patents as almost defensive tools against larger competitors. And to have those patents is a great insurance policy. It's the connection to insurance is quite valid just because it's not something that everybody really wants to pay for, but should probably get in a lot of situations. And only in very specific situations will it be really meaningful. And we found it pretty meaningful in one or two situations. In most of the cases, not that meaningful, but important to have.
And my own response is not that dissimilar from the other members of this panel. I think the answer is it depends. For a lot of the projects that we get involved in, they're really engineering projects, and sometimes the value in the company is embedded really in some tribal knowledge, which is probably best kept unpatented. And there are cases when you do patent it more for defensive purposes so that you can use that when some of the big bad boys come after you, as happened to me when I was CEO of Neoteris. And the other thing I'd say is there are certain projects where IP does matter, even on the tech side. Of course, healthcare is very important on the medical devices and the biopharma side. On the tech side, where we found IP is important, like I'll give you the example of Data Domain. Data Domain was one of our portfolio companies. It had come up with the data deduplication algorithm. Kylie had come up with that, and that's something that we patented early and ended up being a useful patent. Another one that I'm involved in is a company called Cohere Technologies, which has come up with a new wireless modulation scheme, and that's another one that we think is worth patenting. And so it depends on the project that you're involved in, and you can actually get a sense for when it is actually worth spending that additional time and effort to patent it. And we actually do that diligence up front. So we have a venture partner working with us who is a patent attorney, and we will engage him on certain projects, and sometimes even from the freedom to operate point of view to make sure that the company is protected.
So I'm gonna follow up on something you said, Kittu, and was echoed earlier. So first, looking at patents as a defensive tool, I presume that many of you have invested in companies where that company was then approached by a competitor or by a insert acronym here, but patent assertion entity, patent licensing entity, patent troll, depending on your perspective. What advice have you given your companies, and sort of what was the VC's role in the company's responses? And sort of any war stories that you can tell here to bring this alive would be great.
I mean, we had a situation in a portfolio company last year where it's actually just recently resolved, but I don't know there's any brilliant insight. If you're approached by one of those groups, you have to run it to ground. And unfortunately, that's an expensive experience. You have to hire outside, if you have to engage your patent counsel, they have to review all the different facts. Then there's a series of engagements with that other entity. And in our case, it all worked out to our benefit, but still, I'm sure the bill was a couple $100,000. And so, I don't know that there's any, and that's what's frustrating, is that these are somewhat in the realm of frivolous, and yet they waste, they waste resources that could been devoted to creating value, not just sort of paying other lawyers.
Well, I'll give you 3 examples. One that didn't work out well at all for us, another one that worked out okay, and a third one where we were the aggressor. The first example is that of Vonage. So the lesson I take away from the Vonage experience and the advice that I'd give entrepreneurs in the audience is, do not do a patent review. Because if there is evidence that you have done a patent review and then gone ahead and violated that patent, you're in deeper shit than you were.
3 times deeper shit.
Yeah. So Vonage was one such example, because the Vonage guys had actually done a whole bunch of patent review and still went ahead and violated those patents. So when it actually went into litigation, the judge was merciless. And so they had to, I think, shell out close to $200 million. So that was an ouch experience. The second one is my own experience when I was CEO of Neoteris. Within days of the news coming out that our company was getting bought by NetScreen for a significant amount of change, the ink had not dried in the paperwork, and we had a patent troll come after us. And we knew that the claim was completely frivolous. And we decided to fight it, and we hired our patent attorney, and I have my own recommendation of good patent attorneys. And I think there's a patent strategy, which we'll probably cover later in the conversation, that entrepreneurs should embark on. But he fought it very effectively, and we did okay on that. And the third one was we had incubated TiVo at NEA. And I think there was one question where IP is useful. This was a case where IP was actually very useful. Although I must say, what TiVo did was basically what we had done at Silicon Graphics, except that Silicon Graphics didn't have the smarts to go off and patent it. TiVo, the guys who were at SGI left SGI, did the company, patented it, and NEA benefited from it, I guess. But what TiVo did was DirecTV and Dish were both in violation of the patent. And so basically, TiVo sent a letter to both of them saying, you're in violation. DirecTV agreed to a negotiation, and they struck a deal with TiVo. Dish, on the other hand, fought it and lost. Here was a fledgling little company that actually won that lawsuit.
Any other stories? Okay, so I'll build on that point then. So there's sort of patents as the defensive side, which we've talked about. And then there's a variety of other ways to use patents. So there's patents as an offensive tool to block out competition. And then there's also unforeseen uses of patents that have nothing to do with the core business. Maybe the company shuts down. Maybe the patents help you raise money through a royalty monetization or some sort of securitization. So I'm interested to see whether any of you guys have had any experience of patents as an offensive tool. You mentioned one on TiVo.
Yeah, I don't know if this is necessarily an offensive tool, but at Osage we've done a lot of work on what investing in university spinouts looks like, and we've collected data on 20 years of companies that were university spinouts and what the returns have been in those spinouts. And we found some remarkable data on the downside protection that university spinouts generally have, companies that have licensed pretty significant patents from universities versus the general startup kind of ecosystem. And in our data has shown that in large cases, you're likely to get your money back if you invest in a company that has licensed technology. So if you are thinking about starting a company, you should really go to techventures.columbia.edu.
That's why we like John.
Did he just get paid?
I'm sorry, in case you missed it, that's techventures. Yeah.
But patents absolutely have an awful lot of value in an M&A situation. And for a small company to sue a large company is a losing battle because the large company can out-lawyer the small company most times. There are cases where that's not the case, but most times they can just out-lawyer you and outlast you. But an acquirer is in a very different position. And we've sold a lot of companies where the value has gone up a lot because of the patent portfolio, particularly if in the wireless space and you're in the Apple, Samsung, Google place where they love to sue each other and the value of those patents has gotten through the roof. you can generate a lot of value on IP even if your business doesn't work. It's, often the correlation of patents working and business working is looser than we'd like it to be, and it's better to have your business work. But if your business doesn't work, boy, can it help, to your point.
So I think there is a lot of value in certain cases. As I said, for instance, the example that I gave you of the wireless company that I'm an investor in, it does open up business models. You can embark on different, you have optionality, shall we say. And that's something that is valuable. And there are times when you can use it effectively. For instance, one of my companies had a deal in the works with Best Buy. And Best Buy had signed all of these NDAs and things. It's not exactly a patent example, but I'll give you, it's kind of revealing. Best Buy had signed all these NDAs and stuff like that, and then at the 11th hour pulled the rug from under the company. And basically, the company was just out of money and very quickly spiraling to its death. And what we did, we ended up actually selling the company for a small amount of money to Square Trade. But what we did was we used that money to fund our lawsuit against Best Buy. And we won that. And the judge actually not only awarded us damages, but punitive damages, because there was enough evidence that Best Buy was extremely arrogant in the way that it conducted itself. So that's an example of how sometimes you can actually extract value out of the company through the use of
intellectual property.
Exactly. Yeah. Exactly.
Great. So you mentioned earlier, given that each of you have had some experiences about where the patents had value, possibly beyond what the company initially intended, in other situations, as we talked about earlier, patents may not actually be that relevant to the business model of the company in the first place. Do you have any advice for entrepreneurs just starting off about what their patent strategy might be? File broadly, file narrowly, get something on file, don't get anything on file, ex-US versus US only, how much money to budget?
I think it depends on which markets you want to go after. If you're targeting the US and Europe, Japan as countries, those I generally encourage entrepreneurs to file patents in. China is anyone's guess. They do have, China and India both have emerging patent laws, but how enforceable they are is anybody's guess. I haven't had companies successfully defend patents in those countries yet. And so it really depends on which countries and which markets you're going after. But in general, I do encourage them to file these patents and sometimes file provisional so that you buy yourself a little more time if cash is a bit of a crunch. And we usually I hold the CTO responsible for the timely execution of this patent strategy. Talking about strategy itself, what has worked for me is I've worked with John Farrell at Carr & Farrell pretty frequently, and he's a very interesting guy in terms of the kind of patent strategy he embarks on. He likes to file a bunch of interleaving patents. So it's not like you just license one patent. You have to license the entire bunch of patents. And I found that to be a very effective strategy. So that's another thing that I generally advise my companies on. But how much to actually allocate is an art form. It all depends on what the project is and how valuable you think the actual intellectual property is, whether it is for defensive purposes or offensive purposes. And like I said, if it is something that's more of an engineering project, most software companies are, we probably use it relatively sparingly.
It depends, how much to spend on patents is really difficult, I think, because it's a never-ending expense line, essentially. But it has to sort of fit in with the overall expenses of the company. So, it is to the CTO or the VP of R&D's, discretion to sort of say, how much am I willing to spend on research, how much do I want to spend on development, and how much do I have left over for patents? And it becomes that very much, because I was looking at one of our portfolio companies, they have 72 patents. I thought, oh my God, we have spent way too much money on patents if this little company has 72, right? So it can. I don't know. They do have a platform technology, and it's really cool. But we must have filings all over the world. And it depends on your market, and it depends on the dynamics of that market and how people are going to view them. But the crafting the strategy and limiting how much you spend on that on an ongoing basis is really important.
It can get very expensive really fast, right? So I've always encouraged companies to figure out what are the 3, 4, 5 fundamental patents and do that early, but then try to use Kittu's the tactic of provisionals to kick the ball down the field with the other ones, because eventually you have a lot of money if things are well and you can fire a lot of them. But early on, it's I've seen companies, some of my companies unfortunately burn incredible amounts of money really fast because people get very excited about it and you're very proud that you file patents, but it's rare that more than the core is needed at first. Eventually, because when you get in a fight, the core ones are that matter, and then some people get intimidated if you have 72 patents because they say, oh my God, there's so many patents, I don't want to fight with them, right? But that's definitely a secondary thing. Wait till you're rich.
I'm actually an investor in a company in Boston called Levant Power, which is building an active suspension for automobiles. And there is an example where there's quite a bit of the landscape is filled with landmines, and so there was the issue of how will you have the freedom to operate, and so these guys actually were pretty smart about it. They did file a bunch of patents around their innovation to try and use that as a way to effectively block others or defend themselves. And so there, in that example, when we invested in it, we did actually a patent review and then actually asked them to consult with our patent lawyer to craft maybe a more comprehensive patent strategy.
So I'm interested, following up on that, there's certain fields where, obviously everyone in biopharma and medical devices, some in clean energy, there's certain fields, maybe materials, where the patents, especially if it's an actual composition of matter patent, but in some cases a method patent, can be extraordinarily valuable and really are the make and break strategy of the company. There's other fields that are commonly sort of dismissed quite quickly around patents. In particular, you'll hear, oh, it doesn't matter in software companies. But at least in Columbia's experience, I know for quite a number of our peer institutions, some of those have been very commercially successful in certain fields. I'm wondering, have there been examples in your portfolios where a software or an algorithm patents have turned out to be quite useful?
Oh, without a doubt. Without a doubt. Yeah, I think my comment more is software patents tend to get developed over time. It's rare that they're there at the start of the company because software companies pivot so much. And it's rare that what they start to do is exactly what they end up doing. But we had a software company that had some fancy search stuff. This is a few years ago now. They licensed it to Comcast. Comcast decided that they were going to go do it themselves. And and they successfully sued their customer, which was for $30 million, which is a very difficult thing to do. But it was completely a pure software algorithm. But they developed it, they tweaked it over time, and eventually they ended up something that applied really, really well.
Yeah, I mean, we have a number of companies that are selling their products directly into large companies, and it's a consistent worry whether they're securely patented enough or not. And then there's also some worry that if you choose not to patent and a key member on your team leaves, there's also some considerations there as well.
Oh, interesting. So patents is an HR strategy in some ways. Yeah. Huh. Interesting.
In my experience, it's been, we have several examples where companies have effectively used their patents to realize value. I give you the example of Dish. I know of other examples, not within our portfolio, but he was talking about cable companies. And I know one company startup that had actually effectively sued the cable MSOs and the cable labs guys. But the problem is that when you go after the cable industry, they operate as basically a mafia of sorts. It's a cabal. And so, yeah, you may win those $30 million, but you ain't getting any more business after that. So you can kiss that goodbye.
So it's your last business strategy.
Yeah, and actually, if you sign on to cable labs, you basically agree to a 30-day period during which time you can raise your hand and say, wait a second, the standard is violating my patent. And in that 30 period of time, if you're silent, that's it. Whatever you've come up with becomes part of the standard.
Got it. So
But
last,
it
go
is
ahead.
an important consideration. I mean, the dynamics of an industry and particularly the big players in it determine in large part what the value of patents are. Because some of them, there are medical device companies that are very respectful of patents and very careful with entrepreneurs, and then there are others that clearly have a view that they can outspend and outlast any startup. And so they don't really care what your patents are. They're happy to learn your trade secrets, and if you sue them, good luck, because our pocketbook's a lot deeper than yours, and we'll spend you to your oblivion.
And this is where, as giving the example, I have an investment in a cable company, and we have a very explicit strategy on what to patent, because we know when we patent, that will become part of the standard. But there's some part which we haven't patented, and which is part of the sort of the tribal knowledge of the company, and that's how we plan to differentiate ourselves.
And to your point on industries, and there's a company in Boston, Nuance, which is a speech company. The entire strategy is on lawsuits, right? And what they do is when they find a startup that they're interested in acquiring, they sue first, and then they come and eventually come up with a much lower price acquisition. And they've done this successfully for 15 years, right? So if you're in that industry, if you're in the speech industry, you should assume you're going to get sued by Nuance at some point, because everybody does. And then the question, then you really have to know what your patent portfolio is and how you're going to go handle that. And maybe you shouldn't get into it.
That was the article that we sent around, Patent Used as a Sword. It was on the Nuance Flingo lawsuits. Yeah. The people talk about in today, the sort of the chip companies, some of the big software companies are also, some of those strategies seem to be emerging as well. So we'll see where that plays out. Okay, so last question, and then we'll bring everyone up. Chance to give a shout out to patent attorneys that you've worked with that you strongly recommend. You mentioned one before.
Yeah, the guys that I've worked with that I've had good experience, one is Carr and Farrell, and they focus only on intellectual property. They're not a full stop, or the full service shop like a Wilson Sonsini or one of those guys. I've had good experience with even Wilson Sonsini. Seth Goldberg at Wilson Sonsini was really useful. In fact, I switched from our corporate lawyers to Wilson Sonsini because of the intellectual property support.
You got two people taking notes, or actually.
No, we're
playing each
looking
other.
for our
We're
names.
looking for our guys, yeah. I can't find our guy.
They're in a Beans Words with Friends match over here. Anyone else?
Well, I've had good luck with Wilmer Hale, and there's another firm which I was trying to look up. It's a specialized patent firm that is very good, but I can't come up with their name right now.
I don't have any endorsements, but if there's a patent attorney that wants an endorsement, I'll take that.
For a small price.
I had to pay John $50 to give our URL, so I don't know what the patent attorney can get away with. We're just a not-profit. Actually, maybe what we'll do is, as just for the class, if after the class, if any of the panelists have firms they've worked with, either on the corporate side or the patent side, that they've liked and wanted to share them with us, we're happy to circulate them to the class for recommendations. Maybe you can just give the specific attorney as well. But great. So we're going to take another 1 or 2 minute break. We're going to ask all the panelists to come up. We got to figure out how to divide 5 mics among 9 people, so we'll work on that. Brain teaser for us. And then we're going to open it up for, I'm going to ask 1 or 2 questions for the group. In particular, I'm interested to see if any of panel A have questions for panel B and vice versa. And then we'll open it up to the audience for a few more minutes and we'll call it a day. We'll take a break and do the second half of class. So if you got to get up and stretch, feel free to do so. We'll start in about 2 minutes.